death was highly contentious as the evidence emerged, and I shall return to this in due course. Records showed that such attempts by her with plastic bags had been a feature of some of her earlier admissions. In particular, on the 10th of June 2013, she'd been found on the floor of the toilet, described as being in the corridor area, with a plastic bag round her neck, which she had got from the bin. On the 9th of April 2014, she had told staff that she wanted to end it and that they should assist in opening the toilet so she could use a bin liner to suffocate herself. On the 22nd of April of 2014, she was found in her bedroom with a pair of trousers in 2014. She was reported to have made an attempt to use a plastic bag the previous day. I am satisfied from these incidents that you, Mr. Ananakwa, and indeed the Trust, were very well aware of the particular challenge which Alice presented when she was readmitted to the hospital on the 13th of February of 2015 with significant suicidal thoughts, to which she gave effect within 2 days. Coming out of what was described in the Rio notes as the disabled toilet near the office, with a black bag and attempting to tie it around her neck. I note in parentheses that this must be an incorrect description, in that there was no disabled toilet on the ward. Between the 15th of February and the 9th of June, the notes recorded no fewer than 18 separate incidents involving attempts by Alice at self-harm with plastic bags, of which at least half had been sourced from the communal toilet. I say at least half because the Rio notes were unfortunately insufficiently particularised to afford clarity as to the exact location from which other bags had been obtained by her. In addition, I observe that there were in the region of 30 other incidents involving attempts at self-harm using other types of ligature or other items. It was against this background that the communal toilet on the ward and Alice's access to and use of bin bags obtained from that toilet became a focal point of the evidence in the case. It is important to state that each patient on the ward had their own bedroom with an ensuite toilet, so that for the vast majority of the time, other than, for example, if their room was being cleaned, or if for some therapeutic reason they were told not to use their room during the day, they had no need to use the communal toilet, albeit it was more convenient for them to do so if they were in the communal area of the ward. I am satisfied that it was clearly known, both to the staff, including you, Mr. Ananakwa, and to the Trust, that there was a significant potential problem around the issue of bin bags and their use by patients for self-harm, because from the time the ward first opened in 2011, the bins that were provided to all patients in their ensuite toilet did not have plastic bags. In my judgment, there can be no other reason for that decision to have been taken. Alice's ability to access bags from that communal toilet and her propensity to do so was, in my view, a very serious problem, given the potential extremely serious consequences of her doing so when in a suicidal mindset, as she clearly was frequently until around late May, early June. And I am in no doubt that there was a complete failure to adequately assess and manage the risk that this posed. The case against you, Mr. Ananakbar, on count 2, of which you were convicted, was particularised as follows. A, that you took no sufficient steps to arrange the removal of bin bags from the communal areas of Hepworth Ward that were accessible to and capable of use for acts of self-harm, and or B, that you took no sufficient steps to ensure that the communal toilet was locked on a permanent basis, and or C, that you failed to ensure that incidents of self-harm were adequately recorded and addressed, and or D, that you failed to ensure that a sufficient level of observations were undertaken on patients, including Alice. The jury were directed that proof of any of those 4 particulars would suffice to found a conviction. The prosecution submit that there was sufficient evidence from which the court could be sure that each of the 4 was proved. Ms. Khan, on the other hand, has submitted in terms on your behalf, Mr. Ananakbar, that neither A nor C nor D were proved, and that the court could only proceed on the basis of proof of B. It is clearly imperative for me to make findings in this regard, as this goes to the heart of the issue of culpability, and this necessitates looking at each of the particulars in turn, starting with A. So turning then to A, which I repeat was an allegation of taking no sufficient steps to arrange the removal of bin bags from the communal areas of Hepworth Ward that were accessible to and capable of use for acts of self-harm. In support of her submission that the prosecution have failed to prove to the criminal standard this aspect of the case against you, Mr. Ananakbar, Ms. Khan has reminded me at some length in her first sentencing note of the evidence arising out of the events of Sunday the 15th of February, when Alice tied a black bin bag from the at weekends. The following day, Monday the 16th, you rang in sick. You were to tell the police in interview that when you rang in, you were informed about what Alice had done on the Sunday, and that you then instructed staff on the ward to remove plastic bin liners and discuss this with the facilities department, who did so for a few days before then reintroducing them. And you asserted that you followed that instruction up with an email. Ms. Khan relies upon the evidence of Anne Benyor, the deputy ward manager, who stated that she recalled a conversation with you when you directed that the bin bags should be removed from the communal area and communal toilet, but that they were reintroduced the following day because of complaints by the cleaners. Ms. Khan submits that your assertions in this regard were supported by the evidence of Lorna Mess, one of the modern matrons, and by further evidence on the point concerning what was said and done by others in July. For his part, Mr. Atkinson, on behalf of the prosecution, submits that this evidence was at best equivocal. He has reminded me that in relation to the scoping exercise, you, Mr. Ananakwa, made absolutely no reference to this, that Ricky Franks from Interserve had no recollection of it, and that the email that you claim to have sent has never been found. Whilst I accept that there is some force in Mr. Atkinson's submissions, taking into account the evidence relied upon by Ms. Khan in this regard, the conclusion that I have reached on this issue is that I cannot exclude the possibility that you did give such an instruction at this time. I further accept that the removal of all bin bags from the communal areas based upon an instruction by you was not in your gift or remit, in particular, as Dr. Healy stated in evidence, because it was not straightforward, having regard to the issues to which it gave rise concerning infection control, as well as the job of the cleaning staff in emptying the bins. I also accept that you did not bear the sole responsibility for addressing this issue. Having said all of that, apart from giving the instruction about which Anne Benyor gave evidence, which, as I have said, may have led to the fleeting removal of bags, I am satisfied that you did absolutely nothing else to address this issue, notwithstanding the fact that following this incident on the 15th of February, the problem with Alice continuing to use bags for self-harm persisted on a regular basis for the following 3.5 months, with potentially devastating consequences every time that she managed to access a bin bag, such that, in my judgment, this issue should have been a major priority so far as you were concerned. I remind myself that the allegation under A is not that you took no steps to arrange the removal of bin bags, but rather that you took no sufficient steps to do so, the emphasis being upon sufficiency. Against the background that I have set out, I find myself wholly unable to accept Ms. Khan's submission that your instructions following the 15th of February incident alone and by themselves amounted to the taking of sufficient steps to address this problem. The emphasis, as I say, being upon sufficiency. In my judgment, this was such a serious problem that had you been taking reasonable care for Alice's safety, it is an issue to which you should have been returning to more senior members of staff again and again. This you manifestly did not do. I am accordingly entirely satisfied that the fault alleged against you in count 2A has been amply made out. I turn next to the allegation at B, taking no sufficient steps to ensure that the communal toilet was locked on a permanent basis. Whilst, as I have already stated, the removal of bin bags from the communal toilet gave rise to issues regarding infection control and cleaning, I am satisfied that giving instructions for the toilet to be kept locked on a permanent basis by way of a temporary expedient whilst Alice was on the ward and in the acute phase of her illness did not present any such difficulty, nor, in my judgment, any problem beyond one of inconvenience, given that, as I have already said, all the patients had toilets attaching to their own rooms. I remind myself, in considering this issue, that Professor Fahy, a defence witness, stated in terms that keeping that toilet locked was not an insurmountable problem and would not have needed senior management approval if done on a temporary basis. Indeed, Professor Fahy gave evidence that when he undertook a visit to the ward in March of last year, by which time it was incidentally now a male ward, such a step had been taken. The evidence from a variety of different staff members on the ward about instructions regarding the toilet being kept locked was all over the place, such that it was apparent to me that there was very obviously no clear policy in this regard, or if there was, many of the staff had no idea what it was. Save in the later period of her admission, when Alice was much improved, her care plan stipulated that she was not to be allowed access to this toilet, and yet she was regularly able to gain access and to remove bin bags from there, whereas an instruction that the toilet was to be kept locked at all times and the implementation of that instruction would have prevented this from happening. Your failure in this regard was clearly culpable, as Miss Khan has conceded. The next allegation at C concerns the alleged failure to ensure that incidents of self-harm were adequately recorded and addressed. This aspect of the case concerned Datic's reports, which featured prominently in the course of much of the evidence. The prosecution nursing expert, Richard Edgeworth, produced a table which included bag incidents, other ligature incidents, and other self-harm incidents. It did not include head-banging incidents or incidents of assault or abuse. He stated that each of the 51 incidents in the table merited a Datic's report, whereas only 6 had resulted in such a report. That is 11%. He regarded this as a very high failure rate and significantly worse than to be expected generally. Dr. Basu stated there were 64 incidents which ought to have been reported, of which only 16 were, a reporting rate of 25%. Maggie Gardner stated there were 92 incidents of various types which should have resulted in a Datix report, of which only 12 had a reporting rate of 13%. There were 23 incidents involving the tying of a ligature, of which only 4 had resulted in a Datix report, a reporting rate of 17%. She said this represented a severe underreporting of incidents, which was not at all within any margin of error. Ms. Khan submits that I should conclude that this aspect of the prosecution case has not been made out to the criminal standard. In support of that submission, she relies on a number of aspects of the evidence, all of which I do accept. Firstly, that it was the responsibility of the member of staff witnessing the incident to fill out a Datix report. Secondly, that there was evidence that you, Mr. Ananakwa, emphasised to a number of members of the nursing staff the importance of their attendance at training courses relating to Datix reporting. Thirdly, that 2 members of the nursing staff stated that, as they put it, you would go on and on by way of reminders to staff to fill out Datix reports. Against this background, she submits that the failure in reporting lies at the door of individual staff members and that you were not made aware of many of the incidents which had occurred. Hence, she argues, it is difficult to see how you could have ensured that Datix reports were completed. This latter point, as to what you knew about Alice's attempts at self-harm, is of importance in relation to the case against you as a whole. That is, not just in relation to Datix reports. As was your right, Mr. Ananakwa, you chose not to give evidence. Ms. Khan's assertion that you were ignorant of much that went on in relation to Alice is based upon what you said in the course of your police interviews, in which you stated that if incidents had not been recorded, you would not be aware of them unless you read about them on the Rio system or were actually told about them in a handover or at an MDT meeting, and that you were unaware that staff were not completing Datix reports for every reportable incident. Looking at the evidence on this point as a whole, I am entirely sure that you were being economical with the truth as to what you knew, and that you were so in an attempt to minimise your responsibility for what went on the ward as far as Alice's repeated attempts at self-harm were concerned. I have reached that conclusion taking into account the following evidence. Firstly, Anne Benure said, by way of a general observation, that when you came on the ward, if you had been elsewhere, you would have been updated. And I pause there to observe that as the ward manager, that is exactly what one would have expected. Secondly, Oluwakemi Ajose said that if an incident occurred that was not the subject of a Datix, she would escalate it and let the ward manager know. Thirdly, Karen Tynan stated that if you were not on a ward round, she would expect you to be updated. She also said that the subject of the measures necessary to protect Alice was something she talked about with you, and that things were handed over to you. Fourthly, Sipet Mudau said that she would expect that you would catch up and that anything significant regarding the care of a patient, for example, self-harm, would be handed over, and that as far as she was aware, that is what happened. Fifthly, you said yourself in interview, and I quote, "We were all aware the risk was high, and she has made attempts." And you added that if you'd been off for any period of time, you would catch up through the MDT meetings or by reading the handover sheets. Sixthly, you had Alice's mother's email of the 16th of May forwarded to you, in which she spoke about probably more than 15 occasions when Alice had ripped up pillowcases or used plastic bags. Pausing there to deal with that aspect of the evidence, true it is, as Miss Khan has pointed out, that from that date and up to the 7th of July, there were only 3 further bag incidents. But you could not have known that would be the case. Moreover, if prior to receiving that email, you really were ignorant of the extent of Alice's serious and repeated attempts at self-harm, that email would and should have rung major alarm bells with you. And yet, there was no evidence you took any steps to address the grave concerns expressed by Mrs. Figueiredo. Seventhly, you were well aware of Alice's history from her earlier admissions to the ward, and certainly knew of the 3 serious incidents involving attempted self-harm with bin bags on the 15th of February, 18th of March, and 8th of April that led to Datix reports being filed. Eighth, you were well aware that Dr. Perry had provided a second opinion on the 24th of April, which involved an extremely detailed account of Alice's history, and I am in no doubt that you were aware of the contents of that report. I see the time. I'm going to rise there for a few minutes so that everybody who wishes to can observe 2 minutes silence at 11 o'clock.
11th month, guns fell silent on the Western Front, bringing an end to the First World War. Our nation, Commonwealth, has recalled that moment through our armistice and remembrance events down the decades. Decades during which the men and women of our armed services have continued to pay the ultimate sacrifice. And so, we stand here today to remember lives sacrificed in the service of our country and those traumatised and injured in conflict. May we have such a devotion to justice and freedom that the heroism of all who fought and still fight may continue to be remembered in a nation of service and in a world of peace.
please do take your seats. Your Majesty, distinguished guests, Secretary of State and colleagues from across the railway family, I am delighted to welcome you here to London Paddington Station for this very special Poppies to Paddington Remembrance Service on behalf of Great Western Railway and Network Rail Wales and Western. This is our 6th year of Poppies to Paddington. It was an idea born in the depth of the COVID lockdown. We had a message from a charity to asking for help from within the Great Western community. Help for a veteran who just wanted to mark remembrance in that very difficult time. Well, I have to tell you that email inspired us, and we're grateful that representatives of the
important responsibility to ensure that when you came onto the ward each morning, you took active steps to inform yourself of what incidents concerning Alice, if any, had occurred in your absence. It follows that I am satisfied that the allegation against you in count 2C is also amply made out. Before leaving the subject of Datic's reports, I consider it necessary to revisit the 3 such reports that were filed in relation to incidents in which Alice tried to self-harm using a plastic bag. The first, item 28 in the timeline, occurred on the 15th of February. It was a very serious incident. Alice was ward manager. One of your responsibilities was to sign off the Datic's report as the investigator. In the field headed Investigators' Actions, you wrote, and I quote, "Every item that is potentially harmful could be used for suicide action has been removed from the bedroom," unquote. In my judgment, this was clearly inadequate and inappropriate, given that you knew from the Rio record that the bag she had used had not been obtained from the bedroom, but rather from the communal toilet, as to which you made absolutely no mention. Further, in the risk grading section, you rated the likelihood of recurrence as unlikely. I regard that too as being inappropriate and inexplicable, bearing in mind the very serious nature of the incident, coupled with what you knew about Alice's previous history. The next incident which led to a Datic's report occurred on the 18th of March and appeared in the timeline at row 85. According to the Rio entry, it concerned Alice having been found by nursing staff with a black bin bag over her head, attempting to end her life. Alice having reported that she had taken it from the communal area and hidden it in her pyjamas. In the Investigators' Actions section, you wrote, quote, "In terms of plastic bags, the ward has discussed with all patients in community meetings not to bring plastic bags on the ward or to return plastic bags to staff when their relatives bring it to the ward, unquote. Whilst it is true that the origin of this bag was unclear from the Rio record, what you wrote entirely overlooked the fact that bin bags were readily available to patients in the communal toilets, irrespective of bags that patients or their relatives brought onto the ward, which in any event, on the evidence, were taken off them when they arrived on the ward. The third such report at timeline row 149 concerned an incident which occurred on the 8th of April, when Alice was recorded as having grabbed a staff key and attempted to abscond, and had attempted to use quote, all staff informed that keys and fobs to be put in pocket and not make it accessible to patient during specialing, unquote. There was, however, not a word of reference to the bag aspect of this incident, nor to any action that needed to be taken about Alice having yet again accessed a bag, this being the 10th occasion when this had happened in the previous 7 weeks. Moreover, you graded this as unlikely to recur, which, given the history up to this point, is, in my judgment, hard to credit. I regard the way in which you filled out those 3 Datix forms in relation to someone whom you knew to be a very ill young woman at the time as being symptomatic of an approach on your part which was casual, nonchalant, and manifestly inadequate. Lastly, I turn to the 4th aspect of count 2 at D, failing to ensure that a sufficient level of observations were undertaken on patients, including Alice. Ms. Khan submits that this aspect of count 2 has also not been made out. She argues that when you were aware of any difficulties arising out of staff observations, you dealt with the situation swiftly and proactively by removing the relevant staff member from the ward. She further submits that observations cannot eliminate risk and that on many occasions staff managed to intervene and stop attempted self-harm. As to the first point, I accept that there was evidence, certainly of one such occasion. As to the second point, true it is that prior to the time of Alice's death, disaster was averted in that staff were able to intervene and remove items from her that she had seized, and in particular plastic bags of one sort or another, which she was actively in the process of using to harm herself or was about to do so. However, timely staff intervention was never something that could be guaranteed. And the reality of the situation was that if observations were being properly carried out, in my judgment, Alice should not have been able to get hold of such items on no fewer than 18 occasions prior to her death. And you, Mr. Ananakpa, failed to take any steps to investigate how this was able to happen on such a frequent basis when she was on level 3 or level 4 observations, or what steps needed to be undertaken to try and prevent it. I therefore conclude that this aspect of the prosecution case has also been clearly made out to the criminal standard of proof. I turn next to the sentencing guidelines and to the first issue of culpability. Prosecutions submit with reference to the guidelines that this is a case of high culpability, whereas Ms. Khan argues that it is medium culpability. That is, an offence committed through an act or omission which a person exercising reasonable care would not commit. As to this, the nub of her argument is that the court should accept that you, Mr. Ananakwa, were unaware of the number of bag incidents that had occurred, and the court should give you the benefit of the doubt in as far as your assertion in this regard in interview. Nor, Ms. Khan further submits, it is a case of willful blindness. I've already dealt with these arguments to a large extent when looking at the particulars of offence, each of which I found proved to the criminal standard. And I'm simply not able to accept these submissions for the reasons that I have already articulated. Bearing in mind what you knew about Alice's history, the repeated nature of her self-harm over a period of months, and the seriousness of its potential consequences, which was simply not adequately addressed or managed, the fact that there were 4 different aspects of your failure to take reasonable care for Alice's safety, and the fact that you occupied a position of senior responsibility, and taking account of the evidence as a whole, I am satisfied to the required standard that you did have actual foresight of the risks to Alice. Or, if I were wrong about that, that you were so negligent in informing yourself about them that that amounted to willful blindness. I turn next to the question of harm. As the guideline points out, health and safety offences are concerned with failures to manage risks to health and safety and do not require proof that the offence caused any actual harm, the offence being in creating a risk of harm. The guideline goes on to make it clear that the assessment of harm requires a consideration of both the seriousness of the harm risked by the offender's breach and the likelihood of that harm arising. As the evidence pertaining to this aspect of the case is identical in respect of both defendants, it is convenient to deal with both cases under this heading at one and the same time. With regard to the seriousness of the harm risked, both Ms. Khan and Mr. Cooper, King's Counsel for the Trust, realistically concede that there was a risk of level A harm arising, namely death, which accords with that for which the prosecution contend. Next, I am required to consider the likelihood of harm. Ms. Khan submits that it fell between low and medium, and that as at the 7th of July it was low. Mr. Cooper argues the likelihood of harm throughout was low. The prosecution, on the other hand, say that it was high. In support of his argument, Mr. Cooper relies firstly on the fact that there was no evidence as to the risk profiles of other patients on the ward, and no evidence capable of establishing to the criminal standard of proof that other patients used or attempted to use plastic bags to self-harm, or indeed suffered any degree of harm. I accept the force in this point. The focus here is clearly the degree of likelihood of level A harm to Alice. In this regard, Mr. Cooper relies upon the evidence of Mr. Edgeworth and that of Professor Fahey, the latter of whom, since the conclusion of the trial, has provided a further report expressly dealing with this point. He also relies on the statement of Mr. Dix, a defence expert who in the event was not called as a witness and was not therefore the subject of cross-examination. The thrust of their conclusions was to the effect that inpatient suicides were a rare occurrence, particularly where patients were under constant observation, as Alice was, and that many of Alice's self-harming incidents did not appear to be efforts at suicide and involved no more than negligible to moderate injury given staff intervention, as is more particularly set out in paragraph 16 of Professor Fahey's report of the 17th of August. Professor Fahey makes the further point that in his opinion, many of the incidents in which Alice became involved do not appear to have been an effort at fatal self-harm, but can be interpreted as a means of communicating or coping with distress. Overall, Professor Fahey concludes that, and I quote, the availability of rapid and effective clinical intervention meant that the incidents set out in his report were of low lethality, and the likelihood of level A harm occurring in these circumstances was low, unquote. Dr. Taylor, on behalf of the prosecution, has provided the court with a further report dated the 29th of September dealing with this aspect of the case. He makes what I regard as the very reasonable point that it can be very difficult and sometimes impossible to distinguish between self-harm as a means of communicating or coping with distress and self-harm intended to be fatal, and that an individual act of self-harm can in fact be both. Further, in his opinion, some of the acts of self-harm that preceded Alice's death were life-threatening and extremely high risk in terms of potential death. He states, and I agree with this, that whilst analysis of individual incidents is important, it is the repeated acts of self-harm, the continuing trend across multiple incidents, and the failure to manage that risk in terms of Alice's ability to access plastic bags, of which she was, of course, all too aware, which meant that her risk could increase and is more relevant to assessing the likelihood of level A harm arising, which in any event would have been likely to vary significantly over time. Further, as Dr. Taylor has pointed out, only one incident was needed to result in level A harm, and plastic bags can rapidly be lethal when used in the way that Alice had used them. He concludes by saying that if it was capable of being known for certain that staff could be guaranteed always to observe Alice perfectly and to respond immediately and appropriately, then the likelihood of level A harm would indeed have been low. But as this could not be guaranteed, the risk of such harm remained at least moderate, even after her depressive episode had resolved. So a risk that was at least moderate rather than low. Mr. Atkinson points out that where a plastic bag was used by Alice in the manner in which it was, the speed at which loss of consciousness and subsequent cardiorespiratory arrest might occur is difficult to predict and will depend importantly on the way in which the bag was used, the tightness with which it was secured around the head, and the tightness of any seal around the neck. Irreversible brain damage can occur after 3 to 4 minutes of cardiorespiratory arrest, and it is a means of self-harm which can result in level A harm quickly. Whether it does so result may depend on the extent to which help is available or the ease with which help can get to the patient. And in his most recent skeleton argument, Mr. Atkinson maintains his earlier submission that the failures of care in Alice's case in relation to her access to plastic bags carried a high risk of level A harm. For present purposes, I do not propose to reiterate here his analysis. It suffices to say that having given careful consideration to the submissions on both sides and to the experts' reports, and in particular the recent reports of Professor Fahy and Dr. Taylor, I consider a fair conclusion on this issue to be that there was a medium risk of level A harm, at least up until around a month before Alice died. The guidelines next require me under step 1, that is determining the offence category, to consider 2 matters. Firstly, whether the offence exposed a number of members of the public to the risk of harm as opposed to just Alice. The point here being that the greater the number of members of the public, the greater the risk. And secondly, whether the offence was a significant cause of actual harm. If one or both of these factors apply, the court is required to consider either moving up a harm category or substantially moving up within the category range. The first matter is one to which I have already alluded, and I accept on the evidence adduced, which did not establish that any other patient was either actively suicidal at the time nor accessing plastic bags for the purposes of self-harm, that this has not been made out to the criminal standard of proof. As to the second matter, namely whether the offence was a significant cause of actual harm, this is yet again an issue about which the parties disagree. The argument here centres around causation. 2 points arose on the evidence concerning causation, both of which were highly contentious in the trial, and indeed remain so. Firstly, the defence for both parties laid very great emphasis upon Alice's very much recovered state of mind in the last month or so of her life, following her successful ECT treatment, to which I have already referred, and which led to her being permitted, at this time, unescorted Section 17 leave on several occasions, a course of action which all the experts agreed was entirely appropriate. The prosecution, on the other hand, relied upon the following. Firstly, that the largely uncontentious evidence that Alice was highly volatile, impulsive, and unpredictable. Secondly, that although the last bag incident was on the 9th of June, it was nonetheless clear from the Rio notes that in the last 4 weeks or so of her life she continued to have suicidal thoughts, and in particular on the 4th of July. Thirdly, that at this time the note showed that she was being bullied and intimidated by another patient or patients. Fourthly, But also at this time, the notes show that she stated that her eating disorder had got worse and had become intolerable and overwhelming, and she was increasingly frustrated at the lack of progress in getting a readmission to Newmarket House. And fifthly, the fact that she said that she felt less confident when she was around bags and indulged in head banging. The evidence of Dr. Taylor, which I accept, was to the effect that past behaviour is the best predictor of future behaviour, and that in June and July, in his view, Alice remained a long-term high risk of suicide, which was a risk that could fluctuate rapidly, was difficult to predict, and was persistently elevated even when she was not depressed. In my judgment, Alice clearly remained at risk right up to the 7th of July, as events were tragically to prove, albeit I accept the level of risk was clearly much diminished as compared with that which had obtained earlier. I do accept, though, that as at the 7th of July, given her improvement, there was no longer a requirement, as there had been earlier, to restrict her access to plastic bags. Secondly, on causation, and as to the mechanism of death, this turned on the evidence of the pathologist Dr. Simon Poole and the nurse Violet Story, who found Alice in the communal toilet. Violet Story what was the main plank of the submission made on behalf of both defendants at the close of the prosecution case, that there was no case to answer in relation to the manslaughter charges. In the event, I rejected those submissions, but as stated at the outset of these sentencing remarks, the jury acquitted both defendants on those charges. Whether or not they did so based upon this causation issue, as submitted by the defence, can only be a matter of conjecture. Indeed, I would observe in passing, by way of a general observation, that for the reasons set out by Mr. Atkinson in paragraph 3E of his addendum sentencing note of the 18th of August, I regard the reaching of conclusions based upon questions which may have emanated from a single juror as being invidious and inappropriate. To return to the narrative, I have to be sure, to the criminal standard, that the bag did play more than a minimal part in Alice's death. I have no doubt whatsoever that it was Alice's intention that it should. I say that for two reasons. Firstly, this was clearly her preferred method of attempts at suicide and self-harm. Secondly, the laces that she used came from boots access a bag and place it over her head. In addressing this issue, I do not consider it necessary for these purposes to rehearse the detailed evidence and arguments put forward by both sides to the jury and reiterated in their sentencing notes as to the inferences to be drawn from the evidence of these two witnesses, although I accept the defence argument that there is an element of conjecture in the way in which Mr. Atkinson sought to explain Violet Stora's evidence and what inferences could be drawn from it. It suffices to say that having given this matter detailed and anxious consideration, my conclusion is that whilst it is very likely that the bag did play more than a minimal part in Alice's death, I do not feel able to be sure that it did to the criminal standard of proof. It follows from these findings that I do not consider it necessary or appropriate under this heading to move up a harm category, nor to substantially move up within the category range. That deals with the harm aspect of the guidelines, and I return to your individual case, Mr. Ananakwa, drawing together all the conclusions that I have reached as I have set them out in my judgment. As I have set them out. In my judgment, Mr. Ananakwa, this is a high culpability case of Category 2 harm, the starting point for which, according to the guidelines, is 6 months custody, with a range of a Band F fine or high-level community order to 1 year's custody. I then have to consider whether there are any statutory aggravating features, and I am satisfied that there are none. I also need to evaluate whether there are any non-statutory such features. Although I do not add to your sentence on this account, I do not think it would be appropriate in this context for me to entirely ignore the fact that you were the subject of a personal improvement plan between 2011 and December 2014, which, amongst other things, included issues around Datic's reports. I agree with Ms. Khan that the evidence about this was unsatisfactory, not least having regard to the substantially incomplete nature of the records, which were also at times difficult to follow. Its relevance is that albeit you were signed off from it before the events with which the jury were concerned, it was or should have been an additional factor in your mind in terms of the need to give of your best insofar as the performance of your duties was concerned. And this you manifestly did not do. As to mitigation in your case, there is the following, which I regard as being significant. Firstly, the delay. The events with which this case has been concerned occurred over 10 years ago. So you've had this hanging over your head for an extremely long time, including a period of some 5 months since your conviction. I note in this regard that you were not interviewed until January 2019, some 3.5 years after Alice's death, and not charged until September 2023, over 8 years after her death. However complex the investigation was, I do regard this as amounting to an unconscionable delay, and I fully acknowledge how stressful this must have been for you and your family. Secondly, I take into account the fact that you have been a mental health nurse for 23 years and are a family man and a man of previous good character. Thirdly, I've had regard to the various excellent character references that have been submitted on your behalf, as well as the letters that you and your wife have written to the court. Fourthly, I bear in mind that a number of the staff who worked under you in the course of the trial spoke of your attributes in the most glowing of terms. I have in mind in particular the evidence of Karen Tynan and Sipet Mudau, and also that of Anne Benyor, Bayo Adesuyi and Sanjay Agun. Fifthly, I accept this was an extremely busy ward. You had a very high-pressure job with many different responsibilities, and that recruiting and retaining staff of the right calibre was challenging then, as indeed it is now. Sixthly, by reason of your conviction, I recognise that there are potential implications insofar as your career is concerned, although it would appear that that remains to be resolved. I also take into account the contents of the pre-sentence report, although I note from that report that the author writes that you continue to assert that you do not think that you did anything wrong, from which it seems to me it must follow that whilst of course you regret Alice's death, you have no real insight nor any real remorse for what you did, or perhaps more pertinently, what you failed to do. Given the weeks of evidence that you sat through and the many failings which I have identified in these remarks, I find the fact that you clearly remain in a state of denial very troubling, and it does you little credit. Notwithstanding the mitigation to which I have referred, I regard this as being a bad case of its admittedly unusual type. You are in a position of significant responsibility as the ward manager on a closed ward with seriously ill patients. You had a great deal of experience, both in mental health generally, as well as on this ward, and with Alice. You knew that she was suicidal. She was the only patient on the ward at the time who was. Your negligent breach of duty went on for weeks. During that time, again and again, Alice was accessing plastic bags, which had a lethal potential given the state of mind you knew her to be in. And apart from that one instruction that I'm prepared to accept you gave at the very outset of her stay, you effectively did nothing of your own volition to address this very serious issue, whereas it should have been an absolute priority for you. And I regard the fact that certainly up until the beginning of June, Alice had that continued ability to access plastic bags from that toilet as being inexcusable. I therefore conclude that the seriousness of your criminality was such that it can only be marked with a sentence of imprisonment, any other sentence being insufficient. Further, by way of a starting point, having regard to the seriousness of your offending, this should, in my judgment, be towards the top of the range. I must then go on to consider how that should be reduced to take account of the mitigation and also whether it should be immediate or suspended. But for the mitigation, I've come to the conclusion that the appropriate length of sentence, bearing in mind the maximum in the range is a year, would have been 10 months. I reduced that to 6 months to take account of the mitigation. As to whether the sentence should be immediate or suspended, I have had regard to the sentencing guidelines relating to the imposition of community and custodial sentences. Factors indicating that it would not be appropriate to suspend a custodial sentence are that the offender presents a risk or danger to the public, and or that appropriate punishment can only be achieved by immediate custody, and or that there is a history of poor compliance with court orders. Factors indicating that it may be appropriate to suspend a custodial sentence are that there is a realistic prospect of rehabilitation, and or that there is strong personal mitigation, and or that immediate custody will result in significant harmful impact upon others. I am satisfied that those three matters are all applicable in your case, those three latter matters, that is. And taking into account, in particular, the fact that these events occurred over 10 years ago, I am prepared to suspend that period of imprisonment for a period of 12 months. What that means, Mr. Ananakwa, is that provided you commit no further offences punishable with imprisonment in the next 12 months, you will not be called upon to serve this sentence. If, on the other hand, you were to be unwise enough to commit such an offence, it is extremely likely that you would be required to serve that 6 months in addition to any further sentence imposed for the later offence. In addition, by way of giving something back to the community, you will be required in the next 12 months to carry out 300 hours of unpaid work, and there will be a statutory surcharge in the appropriate amount. I turn next to the trust. Quite a number of the factual issues that have arisen in the case of Mr. Ananakwa, which I have already addressed in these sentence remarks, apply equally to the trust, but by no means all do, and I must of course give the two cases entirely separate consideration. It is convenient to deal as a preliminary matter with a point raised by Mr. Cooper to the effect that both prior to the commencement of the trial and during it, the trust offered a plea to the count with which I am now concerned, count 4, if the prosecution were willing to drop the manslaughter charge, which in the event they were not. Mr. Cooper submits that notwithstanding that no plea was ever tendered to count 4, this is a matter which I can and should take into account as a mitigating factor. With all due respect to Mr. Cooper, I regard this as being both novel and simply not in accordance with established sentencing practice or policy, and accordingly it is not a submission to which I find myself able to accede. I remind myself of my legal directions to the jury that the essence of the offence, so far as the trust is concerned, is that they failed to run Hepworth Ward in such a way as not to expose patients, including Alice, to risks to their health and safety in connection with the use of bin bags on the ward for acts of self-harm. I turn next to the issue of the trust's culpability. Mr. Cooper has drawn my attention to the guideline wherein medium culpability is described as including the fact that, quote, systems were in place, but these were not sufficiently adhered to or implemented, unquote. He submits there was a substantial body of evidence from various of the experts to the effect that that was exactly the position here. In the course of submissions yesterday, this point was properly expressly conceded by Mr. Atkinson. I also make it clear that at the time of the events with which this case is concerned, there was no national policy within the NHS, nor in the industry generally, as to the non-use of plastic bags on mental health wards. This being a factor in the guidelines, were it present, as being indicative of high culpability. That said, I am satisfied that a number of high culpability factors do apply in the Trust's case. Namely, firstly, that they ignored concerns raised by employees, including in particular Dr. Soni, Alice's treating clinician. Secondly, that they failed to make appropriate changes following prior incidents involving Alice. And thirdly, that they allowed breaches to subsist over what may be regarded as a long time, that is, at least 3.5 months. Against this background, in the Trust's case, I am satisfied that there are clearly elements of both medium and high culpability, as Mr. Cooper conceded in the course of argument yesterday. I would add, specifically in relation to Alice's attempts at self-harm and suicide, that, especially her use of plastic bags, that I am satisfied that the Trust had actual knowledge from the following: the 3 Datix reports dealing with Alice's use of bags, the information communicated to Dr. Perry and set out in his report, Dr. Soni's knowledge which she had communicated to Dr. Perry, the Chief Nurse's Group report which referred to 3 occasions between October 2014 and March 2015 when plastic bags, detailed Rio notes, and the correspondence from Alice's parents. And I have regard also to the scoping exercise around the subject of the management of plastic bags, which had commenced on the 16th of February, which not only did not even inquire whether there had been any instance of self-harm involving bin bags, but also went completely silent after the 13th of March. In addition, although Alice's care plans referred to the issues that had arisen regarding her use of bin bags, none of them identified any specific strategy as to how they should be addressed, other than that Alice shouldn't be allowed access to the toilet, which, as I have already observed time and time again, was simply not enforced. This all falls to be considered against a background whereby, in the ordinary course of events, a patient would be using the communal toilet with the door closed, thus preventing staff observations of what they were doing in terms of seizing a bag from the bin. Additionally, the fact that Alice was getting hold of and using or attempting to use bags time and again over several weeks. Addressing this issue would not, in my judgment, have given rise to the need for any major or complex decisions of policy, because this was, at the time, very much a temporary problem for only such time as Alice was on the ward. And to resolve it, for example, by keeping that toilet door permanently locked, could scarcely be regarded as a draconian or dramatic measure, nor as representing in any way an insurmountable difficulty, whilst doing nothing gave rise to a potentially catastrophic outcome. Turning to other matters, I accept Mr. Cooper's submission that the Trust should be sentenced on the basis of their breach of duty limited to the period of Alice's 2015 admission. I remind myself that I am dealing with the Trust, as I have Mr. Ananakwa, by reference to reasonable and not optimal standards of care, and that is in relation to standards which obtained in 2015. I also accept that the Trust should not be judged retrospectively against a higher standard than that of any other trust. Rather, the crux of the case against them was, in my judgment, their failure to deal with a serious local problem on one of their wards. Turning to step 2 of the guidelines, it is clearly the case that the Trust are a large organisation having regard to their turnover. As I have already set out, and for the reasons stated, I view this, in the case of the Trust as well, as being a case of category 2 harm, that is category A with a medium likelihood of harm. The starting point for a high culpability such case is £1.1 million, with a range of £550,000 to £2.9 million. Whereas the starting point for a medium culpability such case is £600,000, with a range of £300,000 to £1.5 million. As I have stated, I regard this, in the Trust's case, as having elements of both levels of culpability. That being the case, and in accordance with usual sentencing principles, I regard the most appropriate and the fairest course here as being to take the median figure, which gives a starting point of £850,000 and a range of £425,000 to £2.2 million. As I've already said, I agree that no uplift on those figures is warranted. The principal mitigation here is the lack of previous convictions, the Trust's cooperation with the investigation, and the delay, although in the case of a corporate as opposed to an individual defendant, I do not regard that as carrying any significant weight. The serious nature of this offence, in the respects to which I have referred, would, in my judgment, justify an increase from the starting point of £850,000. But I am satisfied that that is offset by the mitigating factors which I have outlined, such as they are. On a separate note, I also take into account that in a case like this, the conviction itself and the attendant adverse publicity that it will no doubt generate is also of itself a significant penalty. Turning lastly to steps 3 and 4 in the guideline, I have been provided with a statement from Navin Kalia, the Chief Financial Officer of the Trust. In it, I am told the following: that the Trust serves a population of around 4.3 million people. It employs 8,000 staff working across 210 different bases. That for the year ending 2024 to 25, the Trust had a deficit of £23 million. And that as at the 30th of September of this year, their cash balance was as little as £1.1 million. I am told additionally that in the current financial year, the Trust has been required to deliver savings of between 2 and 3% and has had to reduce their costs by £19.6 million, and that their projected income for 2025 to 2026 is £635 million, a decrease of £30 million from the previous year. Also, that the Trust has been asked for this year to deliver savings of 6%, equating to £44 million. It follows from all of that, and I am bound to accept, and the prosecution do not suggest for a moment otherwise, that the Trust's finances are in an absolutely parlous state. I note that at step 3, the court is required to finalise the appropriate level of fine so as to reflect the seriousness of the offence, whilst taking into account the financial circumstances of the offender. The guidelines go on to state that the fine must be sufficiently substantial to have a real economic impact, which will bring home to management the need to comply with health and safety legislation. At step 4, the court is required to consider any wider impacts of the fine within the organisation or on innocent third parties, which includes the impact of the fine on the employment of staff, service users and customers, and that, of course, very much includes patients. The guideline continues that where the fine will fall on a public body, it should normally be substantially reduced if the offending organisation is able to demonstrate that the proposed fine would have a significant impact on the provision of its services. That consideration clearly applies in this case. The agreed figure that the Trust should contribute to the costs of this prosecution is £200,000, and I so order. Taking that into account, and the median starting point to which I have referred, I propose to reflect the impact of the fine on the Trust, having regard to their financial position, by reducing that starting figure by 1/3, so that the fine will be £565,000. And there will be a statutory surcharge also in the case of the Trust in the appropriate amount. Have I now, I know there is a costs issue, and I will come to that later, but other than that, have I dealt with everything that I need to?